It's 6:35 here on Sky 99.5 FM, and we're diving into the big story of the day, the ruling by the appeal court that the UNC's election petitions can go ahead. On the line with us is attorney at law and a member of the Police Service Commission, also a bit of a constitutional expert as well, Martin George. Good morning to you, Martin George.
Hi, good morning to you, Jessime. Good morning, Dr. Wayne, and good morning, Edison. Good morning to your listeners.
Yes, and thank you for giving us some of your time this morning. Now, were you surprised by the ruling of the appeals court yesterday when the announcement was finally made?
To be honest, Jessime, I was not entirely surprised, because when one considers the threshold that you have to reach in terms of, meeting the standard for an application for leave for judicial review, it is not a very high threshold. So I am not entirely surprised. And given the nature of the matter, I would imagine that the court would have felt, out of an abundance of caution, that these issues are too important to basically be knocked out at this preliminary stage. I think they were of the view, I think Justice Jamadar indicated that, given the importance of the matters at hand, that, they ought to be fully ventilated. And of course, I fully support and understand Justice Archie's point about the lack of evidential basis, which I think is a hurdle that the party bringing the motion will not be able to cross at the substantive hearing, because the evidence, I think, will always be lacking. But notwithstanding that, I think in the interest of the public, in the interest of fairness, it may not be a bad thing at all to have a full and wholesome exposition of the matter at the, substantive level, and let us have it fully ventilated and let the court decide on it one way or the other.
Mr. George, this was a majority decision, not a unanimous decision. So I'm wondering, as far as you know, in situations like these, is there any kind of consultation amongst the judges at all, or are these completely independent decisions?
Well, the thing is, I would imagine, as a matter of practical reality, I cannot speak decisively at all in relation to what may have transpired here, but I would imagine, as a matter of practical reality, that there must be some discussion in terms of, what are your fellow judges' views on the issue, because, of course, you must always show that respect for your peers. So I would imagine that there must be some consultation, but notwithstanding the consultation, I think it's a very good sign when we see our Court of Appeal is able to have robustly independent intellectualism such as this, whereby someone can say, well, look, notwithstanding the fact that two of my fellow Court of Appeal judges do not agree with me, I am of the view that A, B, C, and these are my reasons. And the point is, it has been shown, history has proven on more than one occasion, that sometimes the minority decision is ultimately, vindicated at a later stage or in a different forum. So the point is, I think it's good for our jurisprudence to see that our judges are robustly independent in that way, because I think for too long we've had, many decisions of our Court of Appeal that all seem to just, they all seem to go with the flow, so to speak. And, you have unanimous decisions, and no one is stepping out on a limb to say, hey, listen, is there another view? Is there another way to look at it? So I hope that this does spark some sense of, a revival of that type of, intellectual independence, whereby a judge can feel that, look, notwithstanding the fact that my other judges share a different view, my view is ABC. If you remember Lord Denning, one of the greatest English jurists,
yes,
he was always one to go against the grain. He couldn't care if there was 10 or 100 other judges who disagreed with him. He was always one to say, hey, listen, let's look at this differently. Is there another way of approaching this? And history has proven him right. Most of the major jurisprudential developments that have taken place in English law have occurred as a result of Lord Denning's, independence and his robustness. Lord Diplock was another one who had that same kind of fierce independence, whereby he was always willing to go out on a limb and say, listen, this may be how we have been looking at it all the time. However, let's examine our procedure, our process. Is there another way? And that other way has found itself into our local jurisprudence on many occasions, and they have actually been able to create ways that we have seen the law develop, we've seen it grow. So I hope, as I say, that this is the start of, many more decisions such as this, whereby you don't have the unanimity where persons just basically follow the lead and say, okay, I concur. No, let us see people willing to go out and say, hey, listen, I have examined it. I respect the views of my brothers. However, I must respectfully disagree with them because of ABC. I think that is going to augur very well for the growth of the law and the jurisprudence in Trinidad and Tobago.
I want to quote from a section of the Representation of the People Act, Chapter 2, Rule 35, Section 3. No election shall be declared invalid by reason of any act by a returning officer or any other person in breach of his official duty in connection with the election or otherwise, or of the election rules, if it appears to the court, having cognizance of the question, that the act did not materially affect the result of the election. And there is thinking that based on that particular section, that the petition that's being brought could be considered frivolous.
Well, the thing is, you see, Jesse, I always like to give the greatest of respect to persons who file claims and the attorneys who prepare them, in the sense that I want to assume that it's not based on something frivolous and that there is some deep motivation for you to bring it. I mean, if at the end of the day you are not able to have the evidence to sustain your case, then in hindsight, I guess it may be then open to persons to describe it in that manner. But I always like to give the benefit of the doubt, and I would never at all describe an action such as this ab initio as being frivolous. The point is, there are persons who feel very much aggrieved, so therefore they are looking at ways to explore their legal options, and it is the right of individuals so to do. While, there may be others who may have a different view, it's not really, I think, the proper course for us, without a full and wholesome exposition of the matter, to simply describe it as frivolous. I think there are tremendous hurdles that they would have to overcome, and I think evidentially that is their biggest hurdle. When you ask yourself, how can you show that this has negatively or materially affected me in a way that has caused me, quote unquote, to lose the election? Where is that evidence going to come from? You are not able to say who somebody voted for, even though someone may have been one of your most ardent supporters. What goes on in the secrecy of the voting booth is always sanctimonious.
It's sacrosanct.
That's right. It remains sacrosanct. So therefore, you cannot inquire into that. You can't even ask someone. It's not proper to even ask someone who they voted for. So therefore, you cannot say that, look, even if you say that, look, there were some of your supporters who, had they known of the extended time, may have gone to vote, that doesn't carry the argument anywhere, because there's no way of telling who they would have voted for. In other words, it may be a logical assumption, but it's nothing more than that. It's an assumption, it's not a fact. So therefore, that is always going to be the challenge that they face, and I think that's what Justice Archie was adverting to, and he was saying, look, if at this stage you don't even have the evidence, then where are you going? In other words, why should you consume the time, the resources of the court on an argument where evidentially you are hamstrung from the get-go? Now, the point is, it may be that, look, the best option is to let the matter be fully ventilated, and if it is going to be starved of evidence, let it die a natural death there at the court where you have a full exposition of it. So I think that may have been the thinking of his fellow judges who said, let the matter proceed, let it be heard, let it be ventilated, because at the end of the day, it does not remove the monumental evidential challenge that they face.
Martin George, of concern to some is this challenge to the EBC's independence. Under the Constitution, the EBC has the authority and autonomy to conduct elections as it sees fit. It is supposed to be an independent body, not to be influenced, hamstrung, or threatened by any other entity. The EBC exercised its independence in this particular election, and now that independence is being challenged. One of the concerns is that we may see a whittling down or watering down of the independence of the EBC with a move to adjust or change or bring new legislation as well. Your thoughts?
Well, the thing is, I'm not sure that it necessarily has to go that far. I'll tell you why. The point is, notwithstanding the fact that you may have a constitutional remit which allows you, independence in your operations and your functions. The fact is that even in the exercise of those functions, you must not act arbitrarily, capriciously, or, in a manner that can be constituted as Wednesbury unreasonableness. So in other words, your actions must still be in accordance with the principles of natural justice and fairness, equality, and those things. So in that sense, your independence is not entirely unfettered and untrammeled. You don't have that, absolute authority to do as you please, even if it offends, the laws of natural justice and principles of fairness. So I think it's in that sense that you have a small window of opportunity to bring a decision to the court to have it challenged. Take, for instance, the authority of our president, which, by way of the ouster clause has been said that, look, it cannot be challenged, it cannot be questioned. If you recall, in the matter of Nizam Mohammed, where he challenged the decision of the then president, I think it was George Maxwell Richards, when he decided to terminate his appointment as chairman of the Police Service Commission. Mr. Nizam Mohammed took that decision to court and said, hey, listen, in the exercise of his powers, so in other words, I'm not challenging the fact that he does have the power, but in the exercise of that power, Nizam Mohammed claimed that the president did not afford him the principles of fairness and natural justice. And the court, it was Justice Judith Jones, as she then was. She's now in the Court of Appeal, but she was a puny judge at the time. And she ruled in favor of Mr. Mohammed. And she said, hey, listen, yes, that is correct. In other words, even in the exercise of your unfettered, your constitutional absolute authority, there must be some accounting to the principles of fairness and natural justice in the exercise of your decision. You recall also the case of several years ago, James Alba Bain, where in terms of certain appointments that were made by the then president, I think it was Sir Ellis Clark at the time, where certain appointments were made. Persons sought to even challenge that in terms of, the fact that, look, those appointments were made in certain circumstances. But that was on a different basis from what we had in the Nizam Mohammed matter. And in the Nizam Mohammed matter, the court ruled that, look, yes, you must follow the principles of natural justice. So bringing it back to the question of the EBC, I think that if it is that you are able to find that now sliver of an opening to say, well, look, I'm not challenging the fact that they do have the constitutional authority. I'm saying in the exercise of that authority, if they have not followed the principles of natural justice, fairness, equality, then in that sense, the decision can be impugned. So I don't think it in any way seeks to undermine the constitutional authority of the EBC. It's just a question of how you exercise that authority, and it has to be in a manner that can withstand scrutiny. So I think there's nothing wrong at all with examining the process and examining the way it's done, and I think that certainly it can actually lead to a more robust and even more independent EBC, because they themselves will now be fully aware that, look, once we follow certain guidelines, then of course our decisions will not be scrutinized because we have followed the basic principles of natural justice, fairness, and equality.
So, Mr. George, with with all that you shared, the Election and Boundaries Commission application to strike out the petition, which has yet to be heard, should that go forward then, in light of what their independence, their autonomy, and in light of what you shared in the rulings?
Well, exactly, it should go forward, because the same way that you have the other party feeling that, look, we have a legitimate reason to bring an application, then equally the other side could say, look, we have a legitimate reason to ask that it be struck out as being frivolous, vexatious, and having absolutely no basis. And I would imagine that part of that would be not just on the fact of their constitutional independence, but I think they would also be adverting to the fact that the case is starved of evidence. And I think that that's a defect that the applicants will never be able to cure, because at the end of the day, how do you get that evidence? In other words, how do I prove to a tribunal that I have been materially affected? Because it is going to come down to that sooner or later. In other words, once we get past the esoteric, theoretical, legal arguments, which would be, on the issues and the principles. Okay, the fact is, okay, right. So you've established that. Now let's see. How has this quote-unquote breach affected you? And that's where you can never, ever prove that. In other words, you cannot prove that within that hour, the number of persons who voted more for one party or the other. There's absolutely no way anyone on the planet Earth can prove that. So once you cannot prove that, in fact, who knows, it may have been to your benefit for that extra hour, that maybe you got more votes than the other side during that extra hour. But nobody knows, and nobody will ever know that. Not even the chief elections officer, because there's no timestamp on a voting ballot, on a ballot paper. There's no way of knowing who somebody voted for or who they might have voted for if they had known about the extra hour and had gone down to vote. So it's really going to end up just being an argument in theory, and you then now are asking the court to make a quantum leap of supposition and assumption that, look, I am saying because these persons, and of course they will bring witnesses to say, well, look, I am a staunch supporter of the party, and had I known of the extra hour, I would have gone and voted. You could say that till you are blue in the face. It does not change the fact that there is no tangible evidence to show that that would have been your vote and that would have made the difference. And that's where the case, in my respectful view, will ultimately fall upon its own sword, and the case of the applicants will be hoisted on their own petard.
The courts generally don't like to be put in a position where they have to make great leaps of imagination. Anyway, do they, Martin George?
Well, the point is, at the end of the day, you're supposed to be based on evidence. And regardless of how you cut it, slice it, or dice it, if you are lacking the evidence to support your assumption, you see, you may have a legal principle, a legal basis, a legal theory. So the court will accept that, yes, this is the legal scenario. Okay, show us by your evidence how you fit into this category. And that's where I think that connection will never be made. So it's always going to be on the supposition, the assumption. So in other words, one can understand that in your mind, the mind of the applicant, you will feel, and you might be 100% convinced that, look, had my supporters known, they would have overwhelmingly voted and I would have been the winner. And that's all well and good. You are free to make that assumption as an applicant. But the judge cannot at all make that assumption. The judge must have clear, cogent, compelling facts before her for her to say, well, look, on the actual evidence, not the assumption, not the hope, not the wish, not the fantasy. On the actual evidence, I can see that, look, these 30 people had voted, and you cannot prove that. You cannot prove how someone voted or how someone would have voted. And that's always going to be the undoing in this matter, in my respectful view.
We've got a couple of callers who want to join the conversation. Good morning. You're on the Breakfast Roundtable.
Morning. I wanted to make a comment.
Yes, you're on the air. Go ahead, please.
Yeah, morning. Morning. I just want to make a comment on the...
You can't be listening on the radio.
You need to
cannot be
listen on the phone.
radio.
Please go ahead and make your contribution. We're running out of time.
Yes. I just wanted to express my thoughts on the actual day. Now, I live in La Roquette, and I don't know how much, I didn't really check to see what time the rain started. But But one of my main thoughts is that it will teach Trinidadians a lesson, because we have the election day, and the whole day you have to vote, and you're waiting until the last minute.
Mm-hmm.
And I feel that every time we have an election, everybody should go and vote and get it out of the way. And if that had been done, the rain would have made no difference to them. Thank you.
Thanks very much, Kola. Good morning. You're on the Breakfast Roundtable.
Hello, good morning.
Yes, go ahead, please.
Yes, I want to say that I feel that everything will not be okay because they have won this person. Let me tell you why. This 1 hour voting did not affect only the 6 areas. It affected the whole thing. And one of the things that I said is, why you didn't include Tobago? And then, as was said before, you cannot say by 6 o'clock who was in front, because at 6 o'clock some people will be still there voting, and you have to wait until voting is finished. Then everybody, then they have to check. So I feel that it will go through, and it will be a waste of time and money, because there is no way you can say you were the winner by 6 o'clock. Thank you very much.
Thanks very much, Martin George. As we wrap up, your final thoughts and comments on the matter.
Well, the thing is, that second caller, I think I certainly agree with her in terms of the problems with the evidence and the proof. But then still, as I say, I always like to be respectful to persons who bring litigation, and particularly on matters such as this, which affect, understandably, a large section of the population. So I wouldn't describe it as a waste of time, because the point is, one way or the other, we are going to get a decision of a court on the matter. And, of course, it will add to our body of jurisprudence in this jurisdiction. So I wouldn't describe it as a waste of time. So, let's see what the court decides, and let the games begin.
Interesting days ahead, huh?
Yes, indeed. Indeed. But the point about only bringing it in the 6 constituencies is a valid point, because, in other words, there were 41 constituencies. 39 got the extension and not 41. But even out of the 39, you only chose 6. Why only those 6? In other words, there's the counter argument. Is it that in the other constituencies that you didn't choose, that maybe the extension of time works to your advantage? In that case, if you want to overturn the result, then maybe you should apply to overturn the result in all. Why are you selectively cherry-picking these 6? Simply because those were ones you lost, and you thought that maybe you had a chance in those. You understand me? So
yes.
It's a spurious argument, and it's really a specious argument in a sense that is being put forth, and it is not, with the greatest of respect to those purporting to bring it, it's not something that I think can withstand eventual and ultimate scrutiny in the court.
Thanks very much for giving us your time this morning, Martin George.
It's always a pleasure, and nice talking to you guys.
Have a great day. Martin George, attorney at law and a member of the Police Service Commission, and a bit of a constitutional expert as well, weighing in on the recent decision of the appeal court on the UNC election petitions. Many thanks to Republic Bank Limited for